Good afternoon, everyone. Welcome to NatWest and RBS Mentors' third quarterly webinar of the year, From Willful Neglect to Manslaughter, Exploring Legal Offences in the Care Sector. Thank you so much for joining us on this lovely September afternoon. Hopefully the sun is shining wherever you find yourself watching today. My name is Adam Harrison Moran. I'm an employment law and HR business partner at Mentor. We've got a brilliant session lined up for you today. I'm really excited to bring this to you today. Before I introduce you to our co-hosts and amazing guests that we've got lined up for you, I would just like to run through some basic housekeeping. I don't anticipate any disturbances today. My phone is switched off, doorbells are turned off. But as you know, when working from home, anything can happen. So hopefully there'll be no dogs barking in the background today. I hope you all enjoy the next hour with our industry experts. So please give yourselves an hour if you can. Obviously, I appreciate we're all busy people, but take the time, come away from the day job for an hour if you're able to. Please also reach out with your questions throughout today's session. You'll see the Q&A function down below. It is open throughout. So anytime you think of a question, please put it in there. Myself and my amazing co-host will be introduced in a second. We'll be filtering through them throughout the session. We've set plenty of time aside at the end so we can answer as many as the questions as we can for you. Now, we do often get questions on receiving or questions on can we get the slides after the session? Absolutely. All we ask is at the end of today's session, you'll be offered to complete a short survey. There's just a few questions for you to fill out, so please complete it. You'll then be sent over the slide pack along with a recording of the webinar, and you'll also maybe get a sneak peek into what's to come into quarter four. Also, please remember this webinar, it is a high level webinar. It's not intended to give specific legal advice. So if you do have any specific ongoing issues, please do reach out to your mentor contact. Or if you don't have one and you do need some help, please do give us a call and I'm sure we will be able to help. Okay, so that's it for housekeeping. I'm now going to introduce you to our other guests that you'll be meeting today. First and foremost, please welcome my amazing co-host, Lucy Coombs. Lucy, if you're there.
I am indeed, Adam. Morning, everybody. Well,
Lucy?
good afternoon, I should say, everybody.
Thanks, Lucy. And we do have two very special guests from our health and safety legal partners. I'm delighted to introduce Stephanie Lunt, who is Legal Director at Clyde & Co, and Eleanor Sanderson, Regulatory and Corporate Defence Barrister at Mayfair Place Chambers. Good afternoon.
Good afternoon, everyone.
Good afternoon.
Brilliant, thank you for joining. And last but not least, I'm also delighted to introduce our very own Senior Health and Safety Business Partner, Mr. Anthony Barlow.
Good afternoon, everyone.
Cheers, Anthony. Thank you very much. Amazing. Okay, Lucy, shall we get started with our first opening session today?
Absolutely. Thank you so much, Adam. I'm super excited for this, Stephanie and Eleanor. Thank you so much for joining us today. So to kick us off, Stephanie, if I can come to you first, please. So my first question for you is, what are some of the key trends that you're seeing for the care and nursing sector? And if perhaps you can give us a bit of an overview of the key legal duties that we need to be mindful of.
Thanks, Lucy. Yes, of course. So we'll begin with an overview of current trends amongst regulators in the sector. And it's been widely publicised that inspections of care homes and other adult social care settings have been scaled back in the recent years. However, the Care Quality Commission for England, Care Inspectorate for Scotland and Wales, they've now confirmed that they're increasing the frequency and scope of inspections. So this renewed focus is expected to lead to a corresponding rise in enforcement action. And indeed, recent data shows a staggering increase, nearly 700% in prosecutions being brought by the CQC over the past few years. And this sharp rise reflects a more assertive regulatory position, with the CQC investing in additional resources to support more frequent inspections. We can reasonably anticipate there's going to be more enforcement activity that will continue to escalate. And importantly, the CQC is not the only regulator with the appetite for enforcement. The Health and Safety Executive and local authorities are also playing increasingly active roles in monitoring compliance and pursuing breaches in the sector. And penalties for health and safety breaches can be substantial. And generally, we're seeing a steady rise in penalties, which care providers should be taking note of. Another notable trend is a growing focus on individual accountability. So regulators are no longer limiting their scrutiny just to the corporate entities. They're increasingly examining the conduct of individuals within those organisations. And we routinely see cases involving scrutiny of multiple defendants, so the provider, the registered manager, and in some instances, nurses and carers. Finally, there's a clear move to a more joined-up approach to regulation. Rather than just solely focusing on isolated incidents in individual care homes, regulators are increasingly targeting larger care groups and networks. Their aims to ensure that lessons learned from one setting are disseminated across the entire organisation. And this universal approach presents both challenges but also opportunities for providers.
Wow, okay, so that's really interesting. So if we're seeing all those increases in inspections, enforcements, prosecutions, Eleanor, can I bring you in here as defence barrister? What are the types of offences that you're encountering with organisations and individuals? Can you bring those to life for us a little bit, please?
Yes, thanks, Lucy. I'll start, I think, with perhaps the most sobering offence, which I'm sure all participants have heard of today, which is that of gross negligence manslaughter. And it's a form of homicide, and it can result in a prison sentence, potentially of a number of years. And so in a case where that's suspected, it would be the police that would lead the investigation, and they would arrive to take witness statements or interview a suspect. So looking at the elements of the offence, how is it committed by somebody? First of all, that person must owe a duty of care to the person that died. And that's going to be the case in most care settings. Any carer, doctor, nurse, manager will owe that duty to someone they're caring for. Secondly, they have to have breached the duty. What does that mean? Well, it means doing something that they shouldn't have done or failing to do something that they should have done. And that is with an obvious risk of death. And so the breach must have caused the death or contributed to it. But finally, perhaps the most element of the offence that causes the most debate is that the act or omission must be grossly negligent. So the thing they did wrong must be grossly negligent. And that's not a word that we use much in our day-to-day lives, but it means truly exceptionally bad. Not just a mistake or a simple error, but something that's truly bad and should be categorised as a crime. So who can be charged with the offence? Well, anyone who owes that duty to another and breaches it, as I've described, but it can also be a company. And I know both Steph and I have got experience of representing not just people, but also companies charged with gross negligence manslaughter. And in that case, the prosecutor would have to show that someone senior or in charge of the company had done something grossly negligent in a way that caused the death. And in that case, it can lead to potentially unlimited, very high fines indeed. So the next rung down then, I'd say, would be willful neglect or ill treatment. And that's, again, a very serious offence, and it has a maximum of 5 years imprisonment. So what makes bad treatment the offence of ill treatment? Well, it has to be deliberate behaviour. So a carer doing something deliberately wrong to someone in their care or being reckless about it. And it needn't have a lasting effect on that person's health, but it might be something unkind or abusive or any sort of physical assault. And for willful neglect, that's engaged where a carer fails to look after someone properly. And willful means deliberate. So for a carer to commit that offence, they must realise what they're doing to the patient or the service user causes a risk of harming them, but does it anyway. Again, an error or an accident that occurs isn't included in the offence. So in many cases, the investigation by the police will be focusing on whether or not the carer was doing something deliberate, whether it was accidental, whether it was reckless, and in the case of a manager, whether they knew or ought to have known what was going on. And it's also possible for that offence to be committed by a provider based on the way that the care is managed or organised, making the offence more likely.
Okay, thank you, Eleanor. That's Yeah, very sobering stuff. Yeah, thank you for that. So clearly we need to be mindful of these police offences. Stephanie, can I ask, what other offences do we need to be aware of and making sure we're also avoiding?
Thanks, Lucy. So we routinely advise providers who are under investigation for breaches of the Health and Social Care Act 2008. So in these investigations, they're typically led by the CQC, and the two most commonly contravened regulations that we see are Regulation 12, and that's the duty to provide safe care and treatment, which includes taking all reasonable steps to prevent avoidable harm. And then we've got Regulation 13. So that's the duty to safeguard service users from abuse and improper treatment, including a requirement to ensure that systems and processes must be established and operated effectively to prevent abuse of service users. And we see these types of offences arising routinely in high-risk scenarios such as unwitnessed falls, choking incidents, tissue viability issues, medication errors. And in many cases, providers believe that they have robust systems and documentation in place. But the issue arises when staff deviate from established protocols, sometimes without clear explanation, or where there are gaps where procedures were not as robust as first thought. And with the CQC being able to bring criminal prosecutions, which can result in unlimited fines for businesses and potential custodial sentences for individuals, their powers are extensive when they're utilised. So if providers find themselves under the spotlight of the CQC, it's not only criminal enforcement action which they can utilise, they can also put restrictions on providers' registration and also seek to deregister them in really serious circumstances. And moving on, fire safety remains a critical area of compliance for providers, particularly given the vulnerability of service users. So we frequently see enforcement action under the fire safety order, which is overseen by local fire and rescue services. So common breaches include failure to conduct a suitable and sufficient fire risk assessment, inadequate means of escape and emergency routes, poor maintenance of fire safety systems such as alarms and fire doors. And while many providers are diligent in risk assessing the individual service users' risks and needs, the physical care environment can be overlooked, and this can lead to enforcement notices and, in serious cases, criminal prosecutions, again with the prospect of unlimited fines.
Okay, thank you. Thank you for clarifying. Thank you both for clarifying those potential offences. Can we just drill into a little bit? I guess, let's focus on what might be the most serious issues that we could be faced with. So Stephanie, can I ask again, inquests? This is another hugely important topic for the sector. Can you just explain briefly what are inquests and why are they so important for organisations?
Thanks, Lucy. So sadly, when a fatality does occur in an adult social care setting, it often triggers heightened interest from the regulators. So we're seeing the CQC, the HSE, local authorities becoming actively involved in this inquest process, particularly where the circumstance of the death raise concerns about care standards or regulatory compliance. So what is an inquest? It's a formal fact-finding investigation conducted by a coroner when a death is unnatural, violent, or unexpected. And inquests are not held to determine civil or criminal liability, nor do they assign blame, but instead their purpose is to establish the facts surrounding the death. So the coroner seeks to answer 4 questions. Who was the deceased? When did they die? Where did they die? And how did they come by their death? And some of you might have experienced in your roles that inquests can take place months or even years after the death, depending on the complexity of the case and the involvement of other investigations. And they often involve detailed scrutiny of care records, risk assessments, staffing levels, communication between professionals, amongst other things. And in answer to the question of how the deceased came about their death, the coroner may reach what's known as a short form conclusion. So, for example, natural causes, accident, misadventure, suicide. Alternatively, the coroner may issue a narrative conclusion, which is a brief, neutral, and non-judgmental paragraph summarising the circumstance of the death in more detail. And this is commonplace in complex cases where short-form conclusions may not fully reflect the nuances involved. And whilst inquests do not determine liability, they can have serious implications for providers and for individuals.
Thank you, Stephanie. So, Eleanor, just to follow on from that, then, so what are some of these implications that can come out of an inquest?
Yes, well, exactly. So first of all, the conclusion of an inquest and what the coroner finds can lead the police to reopen an investigation into what happened, and particularly into manslaughter. So if the police are investigating a manslaughter charge, that would always happen before the inquest. So for the inquest to be going ahead, it must be that the police have decided not to bring charges. However, if there's an unlawful killing conclusion from the inquest, the police response can then change. So if there's a decision that the service user was unlawfully killed, the case can go back to the police and they can reopen it. And they would look at all of the evidence that was available before that inquest and everything that the witness had said. And there's no time bar on that period they've got to make the decision. So it could be many years after a death that they were still investigating. And it's not just the police who are able to reinvestigate. Another implication is that it may cause the care regulator to look at it again. So if 3 years haven't passed, that being the limit on, for example, the CQC's offences, they may decide to revisit the evidence as well. And so, for example, perhaps a carer had said something at the inquest that they hadn't said in their statement previously, or were critical. That can lead the care regulator to look at it again and potentially take a different decision. And also, it's likely to lead to increased inspections of that particular provider, and that in turn can impact on the rating. Another important thing a coroner can do is write a prevention of future deaths report. And that's part of their jurisdiction, along with reaching a conclusion about the death. So they can look at the circumstances that arose at the time and make a decision whether or not there's a risk of a death happening again. If they think there is, they'll write a report to the provider, and that's publicly available after it's been written, and it requires a response within a certain number of days saying what the provider is going to do to remedy the problem. And that brings me to another potential ramification, which is that of the impact on reputation. And the press are sometimes present at inquests, they're quite entitled to be there. Whether it's local news or national news, depends on the nature of the case. And the conclusion of the coroner isn't allowed to accuse anyone of a crime or say that civil or criminal liability arises of any sort. But it will make it easy for someone in the press to be able to write an article about it, refer to who was involved, and in the case of the care provider, routinely their name will also be used to describe the case. So that's a further implication that's not so much about the regulators, but also the important consideration of reputation.
Yeah, absolutely. I mean, it's just massive, isn't it, Eleanor? So thank you for that. It'd be really helpful. I don't know if you have any case studies, real life inspirations that you can sort of share with us that you can draw on to sort of really, really bring this to life for us.
Absolutely. If I go back to where I started, which is that most serious offence of gross negligence manslaughter, I can think of a case that was actually now some years ago, but it arose out of a medication error. And in this case, it led to a service user receiving 10 times the dose of medication they should have had, because in effect, the nurse had got the decimal point in the wrong place when working out the dose. And so the prosecution was brought of both that nurse and also the registered manager of the home. And I said earlier that simple errors aren't enough to found a charge of manslaughter. So what happened in this case? Well, the prosecution was based on a difficult set of circumstances. This nurse was at the end of her 10.5-hour shift. She'd been the only person on duty. At the home, there should have been, in their policy, another person on duty that night, but there wasn't. The manager had already had a requirement to improve their staffing levels. And there'd previously been complaints from staff that they were having to work past the end of their shift to make sure there was coverage. So that altogether caused the prosecution to bring this very serious charge. And it was an interesting case medically as well, because there were complicating factors which engage expert evidence. And really what that was looking at was whether or not the condition that caused this gentleman's tragic death was actually something that arose in hospital out of the medication error, or was in fact a condition that he'd had in the home beforehand. And that had never been looked at prior to trial by the prosecution, even though the prosecution was many years in the making. So we were successful at the end of the prosecution case in arguing that the case shouldn't go to the jury because they could never be sure quite why the death had occurred, whether it was due to the medication error or due to a pre-existing condition. And the judge did stop the case against both the registered manager and the nurse, and they were found not guilty. But importantly, that wasn't for years until after this death had initially occurred. And both of them lived, obviously, in fear of that prison sentence for very many years. And I note from that as well, it's so important to engage with advisors and lawyers at an early stage so that all the potential avenues of argument can be explored prior to the case reaching trial.
Oh my goodness. It's just so scary to think that you could be in that position. Yeah, really powerful. Thank you, Eleanor. Stephanie, is there any you'd like to share that you can bring to
Yes, of
life for
course.
us?
We recently advised a care assistant who became the subject of a police investigation following a tragic incident at a care home. So the case involved the death of a service user during one-to-one care, and it was alleged that the care assistant had failed to take appropriate steps to ensure the individual's safety after providing them with personal care. The care assistant was arrested shortly after the incident at the care home and interviewed under caution by the police on suspicion of willful neglect and ill treatment. And during the interview, the care assistant provided an account stating that they'd escalated concerns about the service user to senior staff, a key point for the client to demonstrate that they had discharged their obligations, but something which does remain in dispute. So ultimately, the police decided to take no further action due to insufficient evidence. However, an inquest is scheduled to take place nearly 2 years after the incident. So whilst the police's criminal investigation has concluded for the moment, the CQC has taken a keen interest, and there's a risk that they will be considering bringing criminal charges. So with their decision being made after the inquest, the evidence heard at the inquest is going to be pivotal and just shows the impact that an inquest can have in these type of cases.
Absolutely. It's just I can't imagine being arrested, at the end of your shift or during your shift. It's the impact on individuals is just so huge here.
Yeah.
We've got time for probably a couple more. If you've got any other stories you can share with us.
Yeah, absolutely. Another one that's important to think about is, as Steph mentioned earlier, fire safety prosecutions. And in this case, it's one that really reminds us just how far fire safety law stretches into care providers' practices. This case involved very tragic circumstances, and a resident of the home had been smoking outside, and he dropped a cigarette which became lodged underneath him in his wheelchair. He wasn't able to get any help, and he suffered from fatal burns. And the investigation was brought by the Fire and Rescue Service, and in fact it was very lengthy. Again, it went on for years. But what was interesting about it is how far their investigation went into care records and care practices, which you wouldn't in a way expect from the Fire and Rescue Service. So they investigated all of the care policies, and in the end, a prosecution was brought based on this gentleman's smoking risk assessment and whether or not that had been entirely in accordance with company policy. And the company pleaded guilty in that case and received a very large fine. Now, that might sound complex, and you might think, well, it's only in a case of a fatal fire like that it would go on so long and be such a detailed investigation. But that's simply not right in the case of the Fire and Rescue Service. They can inspect at any time. And whenever there's a fire-related aspect of care, that's something that can found a prosecution. They'll consider it part of their remit. So, for example, in an evacuation plan, it could extend to the lifting equipment, the hoist that might be used for a particular resident, whether that's in date, whether it's had the right inspection. Or equally, what might seem like small mistakes, so fire doors that don't shut quite properly, or an item being left in an escape route, like a wheelchair perhaps had been left there. It could even be just for a few moments, but at the time of the inspection, that's what they'd be looking for. So there are lots of Fire and Rescue Service prosecutions now, which result in really very large fines, even when nobody's been hurt. So it's a good reminder that even the little things that might seem less important than issues of care plans and training of carers and staffing, they are equally important. And just things like keeping corridors clear, have to be in managers' minds as much as the larger stuff.
Well, absolutely. Absolutely. Yeah, really fascinating, because you wouldn't necessarily think about someone going outside for a cigarette as being something that's something you've got to do that full risk assessment.
Exactly.
Well, I certainly wouldn't think of that. Yeah, yeah. Stephanie, have you got one more for us before we round this
Yeah,
out?
sure. Thanks, Lucy. A recent health and safety case I was involved in was one involving a care assistant who was sadly crushed when using a platform lift, something really common that we see used in care home settings. So whilst the care assistant was transporting a piece of mobility equipment using the lift, contrary to the home's policy, she entered the lift and travelled with the equipment, where the wheels of the stand aid became caught on the edge of the lift platform. That caused the equipment to become wedged, and the worker was effectively pinned against the wall of the lift shaft, and it sadly resulted in some fatal crushing injuries. So the care home had a policy against using the lift with equipment within it, but it was not adhered to, sadly, at the time of the incident. After some representations to the local authority, who were the regulator for this type of case, no action was taken against our client. And thankfully, the care home had robust training in place and a clear policy on lift use. We were able to say this was a tragic but isolated incident, and it was the record keeping and evidence given by the staff at the inquest which was undoubtedly instrumental for the council reaching their decision.
So that's really useful then. Thank you. So, clear, robust policies, evidence, records, training, that they seem to be the watchwords, across the entire piece here. Just before we wrap up and hand back to Adam, could you just bring us to a conclusion with some final thoughts and comments on any tips that we should be taking away from this, and things you'd really want us to be focusing on?
Yeah, so just some key points from our experience for providers to take away. So a large proportion of prosecutions in the sector by all of the regulators that we encounter relate to failure to properly identify and manage risks. And this highlights the importance of providers and registered managers being aware of all known risks to their residents, service users, and the environment, and taking adequate steps to mitigate these risks. And it's of note that many of the cases that we deal with, the risks were known, and apparently robust policies and procedures were thought to have been in place. But despite this, people in receipt of care and support still came to harm because those policies and procedures weren't followed. And that's a common feature in the inquest work that we undertake, suggesting that it's a common point of weakness across the sector. Finally, documentation in the sector is key. And whilst the shift to electronic care and nursing records has improved things, I think, it's still a major downfall for providers and registered managers. Often we're told that things have been done, but it's simply not been documented. And it's then an uphill battle when you're under the scrutiny of the regulators to evidence what has been done. And in a busy and challenging sector, documentation really can be the key for providers. So in short, if an incident does occur, it is key to ensure that you understand your obligations and risks, cooperate with the regulators so far as possible, and if there are any gaps or vulnerabilities identified, making sure that they're acted upon for the future.
Yeah, absolutely brilliant. Thank you, Stephanie. I think any training that I'll be suggesting to anybody moving forward will definitely start with these case studies. So thank you so much for taking the time to share your expertise and your insights with us. And thank you to you as well, Eleanor. Thank you so much. Adam, back over to you. Thank you.
Fantastic. Thank you so much, Stephanie. Eleanor. That was really, really interesting and insightful. I'm sure those case studies really brought it to life for everybody on the call today. Right, it's time to meet our next guest to see a little bit more about how Mentor can help with our very own Anthony Barlow. Anthony, please come on and introduce yourself.
Okay, I'm Anthony Barlow. I'm a chartered member of IOSH and I'm a senior business partner and consultant for Royal Bank of Scotland and NatWest Mentor.
Fantastic. Pleasure to have you on the call today, Anthony. What I would like to do is just ask you a couple of questions. Obviously, you're the expert. You're going to fill all the dots in on the information, but I just want to ask you a couple of questions, starting with, when you visit a care-focused client, can you talk us through exactly what is it that you're doing for them? What is it you're looking for?
Course, not a problem. Okay, well, we know from a health and safety issues in care homes, they're very wide. So, slip, trips, and falls, fire hazards, infection control, and medication errors, hazardous from hazardous substances, equipment safety, unsafe moving and handling of certainly of items and also people movement, equipment safety, unsafe moving and handling, risk assessments so risk from hot water and hot surfaces. These are all the type of risks that we kind of look at when we go into these locations, and we will follow. In all industries, the health and safety executive have put guidance out, and it's no exception for care homes. In the care home industry, there's a guidance called health and safety. It's called HST 220, which is health and safety in care homes. It's a fantastic document. If you haven't got it, I recommend all care homes download it. It's got a wide variety, so 14 topics of information that care homes should be looking at from a health and safety perspective. And the reason for this is because health and safety that they look at affects not only the staff, but it also affects residents as well, which means that there's a necessity for robust risk assessments, proper training, adherence to safe operating procedures, and a culture of vigilance to create a safe environment in these locations. So when we go to a care home, we will take this kind of document and we will utilize that as our question set. We will look at basic stuff first of all. We will do a site tour. So we'll look at say that if I can. Slips, trips, and falls. We will go through an inspection, walking around the premises. We will also check whether radiator covers are in place, whether there are any sharp points on any of the any shelvings or any bookcases that may be around where someone could fall against them, could cause an injury. We will look at infection control documentation, medical training. Has there been medical administration training, medical awareness training, medicine awareness training? Hazardous substances, where are they stored? What are they stored? Is there oxygen on site? Where is it kept? Where's the signage for that? And what's the procedures and controls for that to make sure that it's not a fire hazard? We'll look at the equipment safety data. We will ask for information on service records, whether it's a hoist service record, a TMV from the tap service record. We will also look at the loader inspections for the lifting equipment. Moving and handling training, especially for people movement, we will ask, have you done the training? How frequent is that training? And where's that documentation? Hot water services, TMV services, temperature checks on the water, whether it's for a safety or it's for Legionnaires, we will check both of those things. We'll also go down to looking at bed rails. Are bed rail checks done? How frequently are those done? And then we'll kind of process that information. And the one thing we'll always say from ourselves when we go into those locations, we won't just leave it there. If we say, have you done training? Have you done an inspection? And the answer is yes. Then the next question will always be, fantastic, show me. Let's have a look at that training. Let's make sure it's in place. Let's make sure it's in date. Make sure that if it's an annual training that it is done and that there's no legacy issues that need to be picked up. We'll also look at what's known as prevention strategies as well. So risk assessments. Let's have a look at all the risk assessments. Let's make sure they're in place. Who are they brought to attention? Are the staff aware of it? Are there safe working procedures in place for some of these things? Even down to basic stuff like the hoist should have a safe working procedure with it. Often we go to care homes and we don't find that. So it's that type of thing. Look, the guidance says you must have this. It is quite a critical part of the safe systems of work. Staff training, some of the prevention strategies. What training is there? Do you have a training matrix? Where is it? Show me it. Let me have a look. What about new starters? What inductions do you have? Fantastic. Show me that. We'll even go down to environmental safety, hygiene, infection control documentation. Have you got it? Where it is? Have you had an IPC, infection prevention control inspection? When was that done? Fantastic. Show me that. Let's have a look. Was there any actions in it? Have you addressed those actions? Let's have a look at where you're up to with that as well. So it's like I say, it's a robust process that we look at. We don't just come in, as it's been mentioned to me in the past. He said you don't come in and have a cup of tea. You actually do the work and you actually delve into everything. And that's our job. It's not to be friends. It's to do the job, to make sure what you're paying for, you're getting. We will inspect everything related to the health and safety in care homes documentation, and we will make sure that we're providing you good advice to make sure you remain compliant.
Fantastic. just a few of the things that you do, Anthony, I'm sure. Brilliant. No, honestly, thank you. That's some really helpful tips and some really good, useful things for people to watch out for when they maybe expect a call from you. Lucy, everything okay?
Absolutely perfect. We've got some questions coming in. Can I just do a very quick reminder that if you've got a question, please pop it in the Q&A chat. And we can't bring anyone in that's raising their hand or wants to speak on the webinar, unfortunately. So if you've got anything you want to jot down to us, please pop that in there. But if I can, no rest for you, I'm afraid, Anthony. I think our first question that's come in, I think it's probably best answered by yourself, if you wouldn't mind. We've got a question here asking about fire risk assessments and self-assessment, and whether that would qualify as meeting the legal requirements under the fire and safety regulations.
So someone doing their own risk assessment, that would depend on competency. So what we always say is if you're having a risk assessment done, it's all about competency. It's always recommended that you have a qualified individual to do the full fire risk assessment. And then from a review point of view, as long as you've got someone competent within your business to look at the reviews of that, then that's perfectly fine. And that should come with some adequate training as well. Fire risk assessments are massively important. So I was going to discuss, obviously, from a fire point of view as well, is, the specifics with the fire risk assessment. So what you've got is the specific vulnerability of your service users, and also the limited staff you might have at certain times of the day. So for instance, the night shift, you might have a really robust evacuation process, whether it's a progressive, horizontal, vertical evacuation process in place. However, when you put it to the night shift test and suddenly you've gone from 20 staff down to 2 staff or 3 staff, does that evacuation process work? Will it work in that point of view? So yeah, so for when you're talking about self-assessment, you should be conducting self-assessments on a regular basis, and then having a competent individual to do a full fire risk assessment on a periodic basis as well.
Perfect. Thank you, Anthony. That's really, really helpful. Eleanor, is it possible I can bring you here, please, on the next question, which is about the Bolam test, if I'm saying that correctly. And the question is about how does the Bolam test apply in criminal investigations?
So you'd see the Bolam test, really. So if we start with that, it's used particularly in the context of medical practitioners and doctors historically, and it's to determine whether or not a doctor's been negligent. And the question that's asked is there a responsible body of medical opinion that would have come to the same decision? So it doesn't mean would every doctor have done the same. It means, is there a responsible body of opinion that would have said, yes, we'd come to this decision? So it is used in the context of criminal investigations, and it's when you're looking at negligence. So in cases of gross negligence manslaughter, a prosecutor would be looking to decide, first of all, was the doctor negligent, or the carer, or indeed the nurse? And they would consider that test, and they'd be looking for expert evidence to say, if they want to bring a prosecution, you need expert evidence to say, no responsible body of doctors would have acted in this way. And then to decide whether it's grossly negligent and not just negligent, they would be looking at how far below the standard that particular practitioner fell. So if it was just below the standard, then you couldn't find a prosecution for gross negligence manslaughter. But if it's something that no responsible body of doctors would have done, and it falls far below the standard, then that's the basis on which you might see the Bolam test engaged. And a similar kind of test applied to, as I say, perhaps nurses or indeed care assistants. And that would be a very rare case, I have to say, but it's always founded on medical evidence and also some evidence about what standards are in the industry. So obviously you wouldn't expect a care assistant to be held to the same standard as a doctor when making clinical decisions. So the prosecutor has to look for expert opinion that's precisely in that field, that gives a proper insight into the standards you'd expect of that level of clinical expertise.
Brilliant. Thank you. So if we're just exploring, talking about, the different levels here, can we just turn our mind for a moment towards perhaps some of the employment law or HR implications that we might be looking at here? I'm sort of thinking, we've talked about, the importance of training. So thinking about induction of staff, thinking about the fact that this is an industry generally that's under quite intense pressure in terms of staffing ratios and attracting and retaining staff, in terms of turnover, things like that. And of course, looking at it from the other perspective, when you have staff serving longer term with you, they've been with you a long time. What are your thoughts in terms of some of the challenges that might be faced by organisations to ensure they are meeting all these regulatory, with specific focus on health and safety requirements? Stephanie, can I come to you first for some insights there, and
Yeah, of
I'll then
course.
perhaps open this up to Eleanor and to Anthony as you work through it.
It is such a challenge, Lucy, for providers, and there is a large amount of agency staff that obviously work within the care sector that just gives that added layer of complexity. So we often see that more permanent staff, obviously used to residents, know their care plans very well. Lots of the cases that Ella and I deal with are cases where something has gone wrong, sometimes with agency staff that just don't know the baseline of residents, and it's being able to show that we've taken those reasonable steps when they come into the business to induct them. They're not going to have a full oversight of all of the 45 residents on that floor, but to know that they've got the ability to be able to get the information that they need to escalate issues and know when to do that to appropriately senior staff. But I will completely admit, Lucy, it is a challenge for providers, particularly where it's within industry that there often can be a lot of carers that English isn't their first language. So when they're completing care notes, for instance, they may not be expressed in a certain way that others, when they review them, perceive them. So there are so many different challenges, but I think it is document keeping is the main key ingredient here, that when we've got agency staff that do come in, for instance, or permanent staff, all of their training records being up to date, them knowing the policies inside out, rather than just paying lip service to the fact that a box has been ticked to say that they've reviewed them and that they understand them. Actually checking in practice that they understand these things is really key, and that gives Ella and I the best basis if we do have to come in unfortunate circumstances, that we're starting a case on good footing.
Yeah, excellent. Thank you, Stephanie. Eleanor, anything you would like to add?
I mean, I agree with Stephanie. It's such a challenge, I think, for providers when it comes to staffing, because inevitably there can be difficult positions to fill, and especially with agency staff, bringing somebody in and then having them trained up and ready to go in almost instantly is such a challenge. And one of the things that I think Stephanie and I come across quite often is difficulties that staff, especially agency staff, have had either accessing the care plan for a particular resident as they go to their room in the night, perhaps. Have they got access to the right care plans there and then, not locked in a cabinet somewhere? Can they get them there and then? And then also, are they able to fill out the care records properly? And so many homes now and social care settings are moving to electronic record keeping, which has a lot of benefits. But there are plenty of occasions, I think, when I've seen cases where a particular carer, perhaps they're new or they're not particularly tech orientated, hasn't been able to use the electronic system. And so you have a situation where perhaps they've got to go to another carer to get it entered because they haven't got a log into the keypad, or little simple problems like that. Then when there's a problem later and there's a regulator there, you have a situation where there's a carer who couldn't fill out the care records. And so perhaps you've got a gap, or perhaps it's filled out 3 hours later because they had to go and speak to another carer who was busy and say, can you help me input these particular observations? So they seem like small problems, but I would say, providers really need to be able to check, can everybody access the care record? Can everybody fill out care records? And something as simple as that can make a huge difference when it comes several months down the line and we as lawyers are trying to piece together and help our client with working out exactly what happened. So that's something we see quite often. That's a tip, I would say.
Yes. Fantastic. Love it. Thank you, Eleanor. Anthony, can I bring you in as well? I know we were talking about the importance of training. Anything you'd like to add in terms of that employment law, onboarding staff, making sure you've got people set up for success?
Yeah, well, yeah, no, just to reiterate, really, we sorry, my internet is unstable at the moment, so hopefully I'm coming across. We that's one of the things that we look at, look, it,
I
we
seem to be losing you, Anthony.
Yeah, we are just, we'll come back to you,
talk
Anthony.
about
Hold those thoughts.
vulnerabilities, and we also talk
We'll
about violence and aggression, positive behavior, safety a within a care home, and they've got to be reviewed on a monthly. Hmm?
I think we'll just pause you there, Anthony, because your connection's not quite strong enough to we're not catching everything you're saying. So hopefully we can get that resolved and you can rejoin and we'll pick up those thoughts. If I can just maybe come back to you, and then come back to you, Stephanie, around I'd like to pick up on this point about how long these investigations or these prosecutions can extend over. And this is probably a very unfair question to ask. I could probably answer it myself. How do we know when these things are over? And what considerations should we be giving to the staff that are involved in these? Any thoughts on that at all?
Thanks, Lucy. That's the first question that we're often asked, Eleanor, isn't it? How long are we going to need to be engaging with you for? And it's how long is a piece of string, unfortunately. With these type of cases, it's not infrequent that we can be in court perhaps 6, 7 years after an incident's happened. And that sounds like such a long period of time. If we factor in the inquest process, there may have been a police investigation, there may then be a HSE or local authority or CQC investigation. Time does really pass on, unfortunately, and we can never give an accurate time frame, unfortunately, with these things. And there's a massive backlog in the criminal courts as well, as we'll know. So it is very much how long is a piece of string. But I completely appreciate, Lucy, as you say, it's very detrimental for staff in particular to be involved with this process for such a long time, and also for a provider to have that uncertainty hanging over them for such a long period of time, where we're seeing the level of fines that are being issued against businesses. To have that prospect for this length of time, we can't underestimate that, Eleanor, at all, can we? In terms of us supporting them, but unfortunately, that are the realms that we're in.
It's right. It's really difficult to estimate at the start how long it's going to go on for. Sometimes it depends on the complexity of the case. So you do have cases where there's been a death, and because of that coroner area, things can progress quite quickly, and hopefully it would be a matter of months you could have the inquest, especially if those who are investigating have made an early decision that there's unlikely to be any offence committed. On the other hand, if you have initial suspicions of an offence being committed, whether by the police investigation or the regulator, it's going to be a long time. And the difficulty is inquests often can't go ahead until that investigation is complete. So when there's a police investigation, the coroner will be waiting for the outcome of that before the inquest can go ahead. In other cases, they can run alongside. So you might find, for example, the Care Quality Commission would say, well, the inquest can go ahead, we're still investigating, and they have a requirement to bring any charges within 3 years. But again, we're looking at years. And the difficulty is that for anyone involved, for the witnesses, their memories fade, and it becomes very difficult to remember exactly how a particular resident was being looked after on that night. Again, bringing us back to why records are so important. And equally, it's horrendous for the families involved, because often, and one could say invariably, families who have been bereaved as well, we have to have them in our thoughts, want the inquest to proceed as quickly as possible. And if there's an ongoing investigation, you're potentially looking at years. So it is, unfortunately, how long is a piece of string, but one can get a bit of an indication on how long it'll take, depending on who's investigating and how complex the case looks like it's likely to be.
Super, thank you. So I guess you've got to consider it, it's from that employee well-being perspective is certainly where I would be coming from, would be a consideration, but also from a practicality perspective, if you've got staff leaving, and yet an investigation is ongoing, that must be incredibly challenging if further questions are coming out. And I appreciate what you're saying about the record keeping piece, but if there are additional questions to be asked, what are your obligations in terms of being able to reach out to the people involved at the time if they are no longer under your control as an employer?
I think that, Lucy, comes to getting everything together early on after an incident's happened. And I think that's really key to act very early on because, records are great, but unless we have that commentary behind them, that's often what we need. We can see that decisions as to why something has been done have been noted down, but the rationale behind that isn't within the records often in a care setting. So it is an industry that has a high turnover of staff, and if there is an inquest, then staff members, unfortunately, who were at the care home at the time, who may have moved on and may not even be in a care home or similar setting nowadays, they would still have to attend an inquest. It obviously makes it more difficult for the provider. It's always important keep the details, the last known address, etc., from any staff members that are leaving, so that they can be passed across if needs be to the coroner if there's an inquest and we can't get hold of them. All those kind of practical considerations. But again, it's an awful experience for staff. They've already been involved, usually in a traumatic incident, and then they're having to relive it a number of years later. But generally, providers are very good at providing the support, and we're also able to give that support about the process as well, to hopefully give them some reassurance if they are giving evidence.
Yeah, absolutely. I think for me, that would all come down to, actually signposting this right from the outset. This is part and parcel of working within this sector. Regrettably, instances like this, there seems to be an increased likelihood that they might occur due to the we've talked about comorbidities before, about these are understandably likely to be more vulnerable people. So if these incidents do occur, setting out right, even before it happens, this is how we will support you. This is our culture. This is what we do. We will, we obviously expect all the correct policies and processes to be followed, but equally we will support you through this in terms of what you might then have to provide through any prosecution or regulatory review. Brilliant. Anthony, it looks like you're back and you look clear and
Lucy, I'm going to
strong internet.
hopefully, if Ant's still there, I can maybe just touch back with him. One of the questions I wanted to ask regarding fire safety, because that's been quite one of the things we've discussed today. If that's okay with you, Ant. Appreciate we're short on time, but just to ask you, could you tell us some of the common issues that you find in the care industry relating to fire safety? Can you hear us? Yeah.
Yeah, okay, sorry, you were asking about the fire safety. Yeah, apologies, to keep buffering. Yeah, the one thing you should be mentioned with the fire, and you talked about competency earlier, is that one thing we see when we go to care homes, and it's a major issue, is wedge fire doors, poor fire doors, the gaps between the front door and the frame. Also, the fact that who fits the fire doors as well, is there is actually a specific course for installation of fire doors, which often we see not being completed by certain joiners. So when they fit the fire doors, you're spending a lot of money on them, and they're not actually being installed correctly. So that's one of the big things. So when you and fire door surveys as well. Are they adequate? You spend a lot of money on a fire door, make sure it's installed by a competent trained joiner. And that competent trained joiner means they've got a qualification in fire door installation. Wedge doors, we see them all over the place. And that's something that needs to stop specifically in a care home. And then the other thing we look at from a fire perspective, like I said to you before about progressive, horizontal, vertical evacuation processes, is it in place? Does it work? and have you practiced it? And if in the event, for instance, think if we go up to a member of care staff, let's go up to one now and ask them, a fire happens now, do you know what to do? Where's the information? Where'd you grab that from? What training you had? Often there's a pause. I'm not really sure. So from, like I say, from a fire perspective, make sure your fire doors have had an assessment done. Make sure compartmentation surveys have been completed. Make sure that your fire risk assessment do it on a regular basis, but also make sure you act on the findings from it. And often what we'll see is the findings and actions come up, they're not acted on. Remember, this is extremely important. Fire safety, specifically with vulnerable service users, is critical to your safety aspects, and make sure it's done properly.
Brilliant. Thank you so much. We got most of that there, the key stuff, Lucy.
Yeah, we did. No, that's wonderful. Thank you, Anthony. Thank you, Eleanor. Thank you, Stephanie. I think over to you, Adam, to round us out. Thank you.
Yeah, brilliant. Perfect. Okay, thank you very much. We are now out of time. Just a reminder, if you would like a copy of the slides and a link to the recording, then please just fill in the short survey at the end of the webinar. If you've auto-enrolled, you'll automatically be registered for our Q4 webinar. So we're looking forward to sharing some details with you shortly on that. But Stephanie, Eleanor, Anthony, thanks so much for your brilliant presentations. Lucy for being a brilliant co-host, and everybody for watching at home as well. Thank you, and hopefully we'll see you next time.
Wonderful. Thank you so much.